employed by these justices. So, for example, Scalia and Thomas would criticize the idea of a right to abortion, or a right to same-sex marriage, or a right to physician-assisted suicide. They would say those results are inconsistent with the original understanding of the 14th Amendment. And I wouldn't, I think, deny that. It's very hard to get out of the original understanding of the 14th Amendment, the idea that women have a right to abortion or gays have a right to marry. But when the issue is campaign finance reform, or affirmative action, or voluntary integration plans, or minority voting districts, or regulatory takings, or the right of organizations like the Boy Scouts to expressive association, which enables them to exclude gays, notwithstanding a public accommodation law barring discrimination based on sexual orientation, or when the issue is the right of Florida judges to order a recount in a presidential election, then suddenly the Constitution bars all of those outcomes without a word about the original understanding of the First Amendment or the 14th Amendment or Article 2, which is the article invoked in Bush versus Gore. Right? The inconvenient fact for these justices is the people who wrote the 14th Amendment did not intend a colorblind Constitution. They were, perhaps ironically, too racist to commit themselves to a colorblind Constitution, but they didn't think it was unconstitutional to segregate schools, and they didn't think it was unconstitutional to exclude African Americans from juries, and they didn't think it was unconstitutional to exclude blacks from voting. That's why they needed to write a 15th Amendment a few years down the road. The framers of the Fifth Amendment, the one with the takings clause, did not think government should have to pay compensation when it simply regulated property in a way which reduced its value as opposed to physically invading it. The framers of the First Amendment did not dream that they were creating a right for corporations to spend money to influence the outcome of political elections, or for private organizations to be somehow immunized from the operation of public accommodation laws barring discrimination. Right? If Justice Scalia and Thomas insist on invalidating affirmative action, voluntary integration programs, minority voting districts, notwithstanding the fact that there is no good legal historical argument justifying these interpretations as a matter of original understanding, then I submit to you they are not really originalists, and I think perhaps that's the best refutation of originalism, that those who purport to be committed to it, in fact, are not consistent in applying it. Last point, and I'm going to stop very soon. I'm now at the end of my time. I'm just going to take 1 or 2 extra minutes. Think of some of the distasteful results that an originalist constitution would require you to stomach. A constitution that does not forbid racial segregation in public schools because it's fairly clear that the original understanding of the 14th Amendment permitted school segregation. A true commitment to originalism would stick us with a constitution that said it's perfectly fine if a state wants to exclude women from practicing law. It would be perfectly fine for a state to decide we're going to require people to own property if they want to vote. It's perfectly fine as punishment for crimes to lop off people's ears. All of those things were perfectly fine according to the original understanding. It's perfectly fine to criminalize sex outside of marriage, and I don't just mean gay sex, I mean any sort of sex, because the people who wrote the 14th Amendment had no problem with anti-fornication laws. You couldn't get confirmed to the judiciary if you held any of those views. That strikes me as pretty good evidence that most Americans don't think that a constitution that would allow all of those things is the sort of constitution that they want. Now, if most Americans don't want their constitution to permit those practices, it would seem like the democratic thing to do is not to use an interpretive methodology that yields those outcomes. And since one of the principal virtues of originalism is that it furthers democracy, it's a little bit hard to reconcile the fact that most Americans would be profoundly uncomfortable with each of these originalist outcomes. Okay, now Alan is going to try to reverse the curse, as we like to say. 4 minutes.
I jotted down some incoherent notes here, and I guess I have 4 minutes. Okay, first of all, I think Professor Klarman overstates the extent to which changed circumstances undermine the original Constitution in the case for adhering to it. But let's say that those changed circumstances do undermine the original Constitution. Where does that leave us? What do? Do we just don't follow it? Does it exist anymore? It's not binding? Right? Or do we just pick those parts we like as opposed to those we don't? I mean, he didn't offer an alternative theory of what we do if, in fact, changed circumstances undermine the original Constitution. But let's take his two primary examples. One was commerce and one was foreign policy. I know exactly how James Madison would vote on the Gun-Free Schools Act. He would say it's unconstitutional. I know that. I had a seance the other night. But I know exactly how he would vote on it. That's an easy one, right? But the translation metaphor that Professor Klarman refers to, I'm all for that. I've never thought of it as soft originalism. I thought of it as correct originalism, right? Which is to say, for instance, the Constitution says Congress can regulate interstate commerce. There are some things that were that were not interstate commerce in 1795, like agriculture, that today might be interstate commerce because things have changed, as Professor Klarman says. The Constitution plainly accommodates that change. That's not hard. That's not complicated. It's easy. And even the pre-New Deal Supreme Court allowed all sorts of regulations of interstate commerce because of these changes in the national market that courts would not have allowed in 1795. That's perfectly consistent with an original meaning approach to interpretation, whether you call soft originalism or translation or what have you. Or about foreign policy. Right? Yes, we are the only remaining superpower. What does that prove? The system worked. Right? I don't think it undermines the system. I saw that right there. The system worked, right? I mean, so it's a great system. I don't think it really undermines our Constitution to point out that yes, times have changed, but we have managed to accommodate those changed circumstances over time, I think, within the framework of our constitutional system. Now, Professor Klarman also claims that originalist judges sometimes reach results that are inconsistent with an originalist approach. First of all, that actually confirms that originalism is a theory, right, in the sense that the alternatives are not, because it actually generates results against which you can compare the results that judges actually reached and subject those judges to criticism, which is a constraint. It's a constraint that none of the other theories provides, and again, I don't think we heard a theory. We didn't hear an alternative theory from Professor Klarman. Right? And I was happy to hear him concede the various virtues of originalism because it is a constraint, a greater constraint than these other theories. But it's also the case that there's lots of instances in which originalists reach results that are inconsistent with their political preferences. You think Justice Scalia is a big fan of flag burning? Right? But no, he was supplied the fifth vote to say that flag burning is protected by the Constitution. Right? Justice Scalia, think he's tough on crime or soft on crime? He's tough on crime, but he led the charge, right, to say that juries, not judges, have to decide, beyond a reasonable doubt, various facts that bear on the severity of a sentence. Right? That's somebody who you would think, oh, he's a conservative law and order guy, he's tough on crime, he would never do that. But he did it, because he thought the original meaning of the Constitution required that. That's just two examples. Drug testing is another example where Justice Scalia took a more progressive, liberal position, protecting the rights of defendants, than so-called moderate judges like Justice O'Connor. Right? He protected the rights of criminal defendants because he thought that's what the Constitution required. So there's lots of times when judges who say they're originalists reach results that are inconsistent with their assumed political preferences because they're adhering to originalism. I want to say something about campaign finance reform. That's a great euphemism, isn't it? What it really means is throwing people in jail for speaking. Right? You want to take out an ad in the newspaper? It costs money to do that? Yes, you're spending money. Buy a printing press, that's spending money. You want to throw me in jail for speaking? Call it campaign finance reform, so half the people don't know what you're doing. Right? And if you really want to be an originalist in the context of campaign finance reform as it applies to corporation, where the heck does Congress get the authority to tell a corporation that it can't speak? Forget about the First Amendment. Is that a regulation of commerce? You can't speak? No, of course not. So the campaign finance approach, Citizens United versus whoever, was the United States, right? Perfectly consistent with an originalist approach to interpretation. A, the government was banning speech. Atlantic Kagan conceded that this statute would allow the United States to throw somebody in jail for printing a book. Sounds like a violation of freedom of speech to me. And also, where did Congress get the authority to do that? Right, so that example, I think, doesn't work. That's entirely consistent with an originalist methodology of interpretation. And Scalia, Thomas, and the other three, Roberts, Kennedy, and somebody else, got it right. Right in that case. And it's perfectly consistent with an originalist approach. I've probably spent more than 4 minutes, so I'll sit down.
if you'll raise your hand, we have some microphones so those in room 127 can hear. So I'm going to call on folks, but if you'll delay for a second until we get a microphone to you. Right here, if you'll wait.
I think you just line up in the side aisles here.
Oh, okay. I think what we're going to do is ask those who have questions to go out to the side of the aisle. Is that what you want to do? Okay. So we've got one here.
All right, is it working?
I believe it is.
I actually have a question for Professor Meese. When the Constitution was originally passed, there was a lot of controversy surrounding it. For example, there was a lot of anti-federalist opposition, and a lot of our nation's original founders, Patrick Henry most famously, was an adamant opponent to the Constitution. As a result of this, we incorporated a Bill of Rights. With that Bill of Rights, we came along with the Ninth Amendment, which said that we have implied rights. So I guess I was curious what you would say as an originalist, given that, and given the concerns of many anti-federalists that